Good morning, members. My name is Bilha Kinyanjui. I'm the managing partner of Wanjiru Kinyanjui Advocates LLP. I am I'm involved in the practice of real estate, commercial, tax, as well as, of course, estate planning. I'm happy to be here as a fellow member, and I'm hoping that we'll have an enjoyable session together.
Good morning, everyone. My name is Njeri Dirango. I work for the firm of McKay Advocates LLP. I'm a senior associate with a wealth of experience of 6 years in practice. And I specialize in the area of real estate, banking, and securities. And I'm also an accredited legal auditor and a certified professional mediator. We are happy to have you today. And it's, Bila, you can agree with me, it's a rather exciting opportunity to be presenting to you again. And our special gratitude to United Women for again calling us back and partnering with us for this exciting session. And today we are going to be covering the ambit of wills. We are going to be covering trust, and also we are asking ourselves what happens in the event that you die without a will. Then we say that the law decides for you, but is there criteria? How does the court get to determine what happens after? These and more exciting things are what we're going to be speaking about, and we are going to be delving into the intricacies. Basically, what we covered during the part 1 of the wills and trust was just an overview of the basics, and right now we are now delving into the more intricate matters and asking ourselves more practical questions. So Bilha, maybe you can tell us what is in store for us. What exactly are we looking at in terms of the intricate matters and issues that we're going to be discussing, and what our members are expecting from us?
Thank you, Njeri. I think, as Njeri has said, just in terms of a recap, we will cover wills. This is basically when you lend your voice to what happens to your estate when you're gone. And then we'll also cover intestacy. This is when the court makes the decision on your behalf because you did not make a decision in your lifetime. And then, of course, lastly, we will deal with trust and also protecting your wealth through generations. And I think from here, maybe I can let Njeri tell us a bit more about wills.
Yeah, so our recap from part 1, we said a will is just basically expressing your intentions about what exactly you intend to do with your property after you have left the earth, and what exactly happens to that property. How does your family get to deal with the property? How do they manage themselves? How do we reduce these kinds of conflict? And basically we are saying, write down your wishes so that you do not have to leave your family in a confused state about how to plan things around your property. So a will, basically we're saying is that it's a legal document to begin with, but it's most importantly is that it's an expression of the intention of a testator being the person who makes the will. Now, when you can no longer speak, then the will speaks for you. Now, I think, Bilha, you can agree with me from the recap of our last meeting, we delved into various issues and components of a valid will. Yeah. Will you talk more to take us through? Yes.
Okay, I can highlight what makes a will valid. Of course, the testator, as you have been told by Njeri, is the person who writes the will. And one of the key components is that this person must be of sound mind and must act voluntarily. They cannot be coerced. The minute you coerce somebody or direct them in terms of writing the will, that will becomes contestable. The other thing is that wills should be in writing. However, there are some exceptions. There are oral wills that are allowed, and oral wills, there are limitations in that for a will to be oral and to be held to be valid, it can only be valid if you pass on within a period of 3 months. Beyond this, then that oral will is no longer valid. So writing the will still remains the way to go. Then it must be signed by the testator in the presence of 2 witnesses. And of course, these witnesses must be independent. They must be people of course, sound mind, and they must not have an interest in the estate. It's not allowed to have, say, a beneficiary of the estate sign as a witness because it calls to question anything that has been bequeathed to them in that will. So that's a clear requirement. Then, of course, the will must state who the beneficiaries are and also clearly identify the assets that are being being bequeathed in that will, because the minute there is an uncertainty. You say my child, but you've not said which child. Those are things that would be a challenge. So those are, I'd say, the 5 key components of a valid will.
But Bill, I'm just wondering, when someone is writing their will, and maybe I'm a brother and you've appointed me as an executor of the will, can I also witness the will? Because we are saying that a will has to have 2 independent witnesses who are supposed to sign off on the will and say that the testator saw them sign.
I believe so long as this person has no personal interest, meaning that they're not a beneficiary. An executor does not have a personal interest. You may have executors perhaps who are also beneficiaries. So if they tick those 2 boxes, then they should not witness the will. However, if they're purely executors, then there's no reason why. So long as that angle of independence remains, they can be witnesses to the will.
Okay. Yeah. And what about, and when you're writing the will, and you have young children, also the issue of young children also writing wills is also coming up. Can a person who is under the age of 18 write a will?
No, because of course they do not have, they are not of the age of majority. Because like any other thing, say even a contract, you need to be of an age of majority where you understand what it is that you're doing. But if you don't have that age of majority, then you don't have the capacity. Actually, so the capacity test would fail. Yeah.
So in a hypothetical situation, John has a family, he has a wife, he has children, he has businesses, he has land. But John died without writing a will. And we are looking at why exactly it's important for John to have written one. Maybe just talk to us more about that.
Okay, so maybe based on your scenario, maybe we can also assume, say, John had a house, which he owned jointly, say, with his wife. And then he had a property in the village, or shags as the younger people would call it. And then he probably also had an investment property. So for the property that is maybe owned by him and his wife, perhaps they had some foresight and were joint tenants. And we will delve into what joint tenancy is. If that property was owned as joint tenants, upon his demise, then the family would be protected to some level, because automatically, without even going through a probate process, that property becomes the property of his wife. However, these other properties that are in different places in Kenya, one in the village, maybe this investment property in Nairobi, an apartment or something like that, those ones now fall under his estate. And because there is no will, then as we said, remember we said you either make a will so that your view and your wishes are held, or if you don't make one, then the court has to make a decision. And I know later in this presentation, we'll address how now the court makes a decision where John has not written a will. So we can keep in mind this property in the village and this other property, investment property, an apartment in Nairobi, those ones need to be spoken for. Yeah.
Okay, thank you very much for that, Bilha. And even as she's speaking, I am just looking at the intricacies of the family unit, and we are saying when you're writing a will, there are matters that we need to consider. Bill has talked about the components of a valid will, and you are saying that it has to be written, it has to be set down in writing, it has to have a witness, the testator must be of sound mind, and of course now you have to have a recollection of all the assets that you own, and most importantly, the testator must have a recollection of the dependents. Why? Is because we are going to delve into a case whereby there are 2 scenarios. A testator has decided to pick and choose which of the children are going to inherit, and we're going to be looking at what the court has interpreted in terms of these kinds of wills. And we are going to be delving into issues of why a will can be challenged and under what circumstances. So Bilha, I know there are types of wills. So we are saying that a will can be written, but there are other types of wills that also take different forms and under what circumstances. And are these wills valid, or they can be challenged in courts?
Okay, I think other than written wills, I think the 2 other major categories are the oral wills, which I had explained, what qualifies as an oral will, and of course privileged wills, which are now what is open to use by, say, the armed forces and the Marines. And maybe now, as we've talked about wills, perhaps there's also room for us to talk about, now that you have a will, what happens? What happens when you have a will, the person has passed on? What are the next steps? Because today we are trying to be as practical as possible, so that then this does not remain a thing that the lawyers are saying. It's a practical guide as to what happens when a person passes on and they have a will. Jerry, maybe you can take us through that.
Yes, Bella. Thank you very much. Now, you have written a will, and now you have passed on. Where do you start? Where does your family start? Now, the first thing that starts when you have a will is for you to file for probate, or rather for the family to file for probate. This is now the court process. So we are basically saying, for your intention, or you have already expressed your intentions in a written document, and you now need these intentions to be taken seriously by the court, and for the distribution of your property to begin, and for the court to give effect to your wishes in the will. The first place that you start is for filing the letters of the grant of probate. This is a petition that is filed in court. You will feel free to engage me or Bilha or any other legal officer to assist you with the petition filing. You will need to have the proper documentation, that is now the will itself, and it has to be the valid will that indeed that the testator wrote. And secondly, you will need to have the consensus of all the beneficiary. There's a form that is filed. You will need to get the letters from the chief. You will need to have the copies of all the properties together with the original titles. And then now you file the application in court, and the court gives what we call a simple grant. Now, once you have been given a simple grant of probate, then it proceeds now and confirms the grant, and you get what is called the certificate of confirmation of probate. Then from there, you can now proceed as the family through the help of the executors that are named in the will. These are now the people, or rather the officials that are appointed by the testator to ensure that the property is distributed accordingly. Now, once that is done, then we can now proceed and give effect to the wishes of the testator. Now, Bilha, I have heard of situations whereby wills have been challenged. And before, even when we are going through this process for filing for probate, we have had instances whereby beneficiaries come and object to the will in court. Take us through some of the reasons why the court would actually give a listening ear to the beneficiaries or any other interested person, despite someone writing expressly what they wanted to happen in the event of their death.
Okay, thank you, Jerry. So there are various instances where a will can be contested, and one of the key things is capacity. So for instance, as Njeri had proposed, what if a 15-year-old purported to have written a will? Then of course that will is not valid. And then also, is this person of sound mind? If they're not of sound mind, then that is a challenge. Then how did you execute the will? Perhaps I say, John, in our case, the scenario that Njeri had told us about, if John signed a will, but not in the presence of two witnesses. So two witnesses, yes, witness it, but they did not actually see him sign it. So it's a key component that signing must happen in the presence of the witnesses, not that John signs, then takes the will to two other people who are independent and they sign. So those are key components. Then if there was influence, so assuming John was unwell, and there's actually a case about this, Jerry. So in the case of the estate of J and G, what happens is that this gentleman was unwell, and while he was sick in bed, they said 7 days before he succumbed to his illness, he signed a will. His widow, of course, later said that the will was a forgery because he did not have capacity to understand what it is that he was signing. So when you talk about third-party influence, if this person is so sick that maybe now the lawyer and perhaps one of the family members is the one directing him on how to write a will, then that would be a grounds for challenging a will. Then another scenario is if you write a will prior to getting married and it's not in anticipation of marriage. So a young man, assume John, before he got married, had written a will, and this was not in anticipation. For instance, maybe just before getting married, he makes provisions for his will, say maybe even 5 years before, even before he had an idea that he'll be married and have children. So if he wrote that will, it will be revoked because it was done prior to marriage. And of course, even on remarriage, so perhaps you're divorced and you remarry again, those are grounds for revocation. Then lastly, of course, the one that is, I think the one that is always in the public eye, dependents. We're always having many scenarios where dependents have been left out for one reason or another. And that is one of the key reasons that wills can be challenged. And challenge doesn't mean necessarily that the challenge will be successful, but it will be a grounds that someone can use to say I was left out without reason. I am challenging. Yeah. So maybe you can also, I know there are several other instances. Perhaps case law has many examples. So maybe Jerry, you have something in mind that you can illustrate?
Yes. Basing on the fact that we live in an African society, I have seen instances, even in the interpretation of court, there are these instances that are coming up that we have someone writing a will and they actually choose to leave out their girl children on the basis of my daughters will remarry and they will go to another family. They will acquire assets there, and hence they will inherit on their husband in their husband's estate and through now their husband's lineage. These are some of the things that the court is taking so seriously because when the Constitution of Kenya 2010 came into place, there is this specific article, Article 27, that clearly says that no one can discriminate anyone based on gender or even marriage. So there is the case of the estate of JOO, where a man had bequeathed their properties, and in their will, he categorically left out his daughters based on the fact that they will remarry and actually go and inherit in their husband's properties. And in actually ruling in that case, the court said that this will was actually invalid and it failed for reason of discrimination. So these are some of the circumstances that we are seeing, and the court is actually taking these things very seriously, that you cannot discriminate your children. One of the powers of a testator is the ability to have a recollection of all their dependents. Now, the dependents are either male or female. All of them, whether these dependents are legitimate children, illegitimate children, adopted children, all of them, you have to have a recollection of them. And when you are excluding someone from the will, you have to categorically say that you're excluding them for one reason or the other. For example, if you say that if, for example, during your lifetime, you have provided for this child in that you had already given them properties here and there, and you feel that if you had continued to allocate more properties in the will, it will be an unfair advantage to your other children. Then in your will, you have to categorically state that you're excluding A and B because during my lifetime, I had provided for them and I gave them this property, title number this, I gave them my shares in this company, I gave them my nomination in this place. So you have to state why, and the reasons have to be valid. Otherwise, the court will take that certainly no person or no parent will just randomly disinherit their children unfairly. So these are some of the circumstances that the court looks at when they're actually reviewing it. Okay. And when it comes to testators and excluding their children, even behavior, now this goes to some of the dependents and maybe why some of the parents will actually exclude in your will. The way you treated someone when they are alive actually matters. And the court will actually take this as an expression of the intention of the testator to exclude you. If, for example, you are involved in mistreating your parents during their lifetime, they have a valid reason to actually exclude you and say, my child A mistreated me while I was alive. He or she did not cater for me when I was alive, and so they are not entitled to benefit under my estate. So actually the court gives these intentions a listening ear, and they say, looking at the circumstances, you actually mistreated your parent and it will be unfair and contra justice that we should allow you benefit from the estate. And now secondly, we have had instances where children actually are involved in the death of their parents. this is actually a criminal offense. You cannot benefit from an unfairness. Now, you cannot kill your parent and expect to benefit from their estate. Bilha, there's this circumstance whereby when I am a drawer of a will and I had a good relationship with the person who was making the will, and they decide, I'm actually going to give Njeri 10 acres of my land. Then when the person passes, the family comes to contest and say, no, the lawyer actually redrafted the will and inserted clauses and said that this lawyer is actually involved in messing up the will, and so we want the will revoked, because these are some of the reasons why a will can be revoked. Maybe talk to us more about that. How has the court interpreted it? Yeah. Can a lawyer or rather a major beneficiary in the will give rise to suspicious circumstances, and what exactly happens?
I think as I'd highlighted, the key things that cause a will to be challenged, that falls straight into the third party influence, because as a lawyer, your client comes to you seeking guidance. So already you have some level of influence in the guidance. So if at all this client believes that for one reason or another they need to bequeath you with something, then you should recuse yourself and let a different advocate independently give this client the directions on how to write their will in terms of what to follow in terms of the law, but not the content. Who should get what should not be a lawyer's determination. And if this lawyer is supposed to be benefiting from that estate, then they have a conflict of interest and should definitely not be involved in it. And Njeri, now that you mentioned dependence, I think it's important that because this is I think an age-old question as to who is a dependent. So maybe, and this one we will pick exactly what is in the law. What does the law say about dependency? Who is a dependent?
Okay. So now the law defines categorically as a dependent, and I'll read verbatim for purposes of this discussion, that it is a spouse or spouses and includes separated spouses and the children, biological and adopted, including posthumous children of the deceased, whether or not maintained by the deceased immediately prior to his or their death. And B, there is a hierarchy and there is a category. So we move to category B. The deceased parents, step parents, grandparents, grandchildren, stepchildren, the children whom the deceased has taken into his family or their family, their own brothers and sisters, half brothers and sisters, as were being maintained by the deceased prior to his or their death, a divorced spouse being maintained by the deceased voluntarily or through a court order also falls in this category. However, we are going to delve in the issue of former spouses. This is an intricate decision, because we are seeing recent rulings basically just having a discussion around that. Yeah. And Bilha, you can agree with me that this hierarchy is something that the court is taking out very seriously.
Yes.
Earlier we had said that one of the reasons a will can fail is when a testator leaves out their dependents. And that's why we are actually delving into this issue, because if you do not have a clear recollection of all the dependents and people you actually maintained, they can actually go to court and say, no, I was being maintained by this person when they are alive. Why then should I be left out? And they were maintaining me. So also the estate should provide for me, because otherwise I'll be left out. Yeah. So Bilha, please talk to us about that, because I'm seeing that most of the wills actually fails because of dependency. We have so many people coming when the person has died and they are saying, even me, I want to be provided for. I was also a child of this one.
Yeah. And I think, and as you say, it's important for them to take stock. Actually, the word, as you say, is to take stock, of your circumstances, because you see some of the people that have been catered for here are people such as your brothers and sisters. Remember, there is a hierarchy.
Yeah.
But the minute you also are continuously, because the key highlight here is they were being maintained by the deceased immediately prior. So for instance, if you are taking your brother through school, they are not in category A dependents, but they do qualify as a dependent. So when you're writing a will, if this is a continuous, say your brother is of tender years and is going to be in school for a long period of time, and maybe immediately prior to your death, you are maintaining them, then this would be a person who under category B has an interest in the estate. So perhaps it's to build structures that are, you take stock of your own family unit, because one person's scenario is not the same as another.
Yeah.
So if you take stock of your family unit, then you build with the help of maybe legal guidance, a will that actually takes care of everybody that is in your ecosystem that is recognized by the law. And perhaps we can also talk about what happens if now there is no will. So remember John, he didn't have a will. So what happens when it's now left to the court? We have understood who the dependents are. When it goes to court, of course, there's another level of, there are certain sections of the Law of Succession Act, which is between section 35, 36, 39, and 40, that now speaks specifically to what happens in such a scenario. So for one, if you have a surviving spouse and children, your personal and household effects and a life interest goes to your spouse. This is where there is no will. So a life interest in the residue estate goes to your spouse. In the event that you only have a spouse, then yes, they get the personal and household effects and an absolute and life interest. And a life interest in the residue of the estate. So question is, what if in your will you decided to give your personal and household effects to somebody? What happens? See, there are certain things that are almost carved out.
Yes.
To be things that are, or even your matrimonial property to a stranger, somebody who is not in your will. So these are things that, again, with legal guidance, you'd be able to make sure you're not making those mistakes. Because yes, you have a valid will, it's written, it's signed in front of witnesses. But then now when you come to certain things that you have done inside there, you have created maybe things that can be contested. Then of course, if you have no spouse, before we go to not having a spouse, what if you're polygamous? If you are married under a law that allows for polygamy, so for instance, if Islamic law, but of course, even the probate process for Islamic law is a very different and distinct process. But if you're married in a system that allows for polygamy, then of course, they will divide, the division of property happens based on the household. So if you have 2 or 3 wives, then the division happens based on the households, and of course, based on the number of children in those households. And then the wives of this person are also counted as units. Excuse me.
Now, Bilha, I wanted to ask, in a scenario where I'm looking at the hierarchy and how the court is interpreting the distribution and how it is deciding on who gets what when you have not decided who gets what under the will. So again, ladies and gentlemen, I'm reminding you to write wills, because if you do not, the court will. So, Bilha, I'm saying, what does it mean when it comes to matrimonial property? Can I decide that I'm giving the matrimonial home to my children and skip my husband?
Excuse me, Jerry. So as I said, the rights of your spouse will have to be protected.
Yes.
So you need guidance as you're doing this, so that you're not going against the law as you're distinctly giving different properties, so that you ensure that you are working within the confines of the law. Yeah.
And also, what does it mean when someone says that they have a life interest in a property?
Okay. A life interest means that they have the right to use this property in their lifetime.
Yeah.
Upon their demise, then of course, if you had other beneficiaries, say children, then they would be the ones maybe the distribution can happen to. But it's only during their lifetime. And then also, of course, if this person remarries, a life interest can terminate due to remarriage. So these are some of the things to keep in mind when one is making these provisions, or if you do not make the provisions, what the law then provides
for it. So what I'm recapping is that when you have a life interest, please ensure that this property you are actually given, when you have a life interest in a matrimonial home, that means you as a spouse, you cannot sell, you cannot transfer that property, you cannot lease that property, because that property you are given by the court for only usage during your lifetime. And why the court put it that way is for the preservation of the estate of the deceased person and continuity. Because remember, the matrimonial home is also a family home. And we are trying to protect also the spouses themselves. Because in a situation whereby someone has died and they decide that I'm giving my matrimonial home to my children, that means if there is ever any conflict, my children can actually kick out my wife, and you would leave your wife outside, outside in the cold without anywhere to live. and vice versa. This also applies to men as well. Your wife has died and they've decided that they are going to give the matrimonial home to their children because they are protecting their children's estate, or rather their well-being, and they actually decide to kick out their father from the home. So the life interest basically means that the spouse's interest remains protected, and they are given this matrimonial home or matrimonial property to use during their lifetime for their own benefit and for their own protection, also to preserve the dignity of the spouse and to ensure that we do not have instances whereby you actually disinherit your own spouse, even from the home the two of you actually built together. So we are going to be looking at matrimonial property later, and actually what it means in relation to this life interest, and whether in a situation whereby a spouse where a spouse does not have anything to actually maybe some of the basic needs like food, water, or even or even to pay for their needs, what does that mean in relation to them? Can they actually go to court and apply for reasonable provision and actually be let by the court to sell some of the assets to actually maintain themselves? Because I've seen some of these things coming up whereby you find that the matrimonial house and the matrimonial compound are actually within acres and acres of land. And then because this spouse has actually been given a life interest, the wife is now, or rather the husband, has been left with a house, with the assets, with large acres of land where the matrimonial compound is, and they can actually not even subdivide and sell because it's a life interest, and they are not allowed to. But this person is actually starving. So what is the use for a spouse to actually have an asset that can actually, that doesn't even help them? Yeah, because I've seen those scenarios, and it's actually some of the things that are giving rise to discussions in law, and we are wondering, that is the spouse protected when you actually have an asset and you actually have acres of land that you've been left to that can actually can't help you when you need to provide for yourself? Because also remember, some of these caterings are also done in old age. Now you have a senior citizen, they are not working, you have the matrimonial home, the matrimonial compound, you have a life interest you cannot sell.
I think based on that, and I suppose that also then gives even more reason why one needs to take time, to take stock, and to also protect your loved ones in your absence by now having a session where you sit down and think through. If, say, as you're saying, this is a large parcel of land, say it's 20 acres, but on that one title there's a matrimonial home, then you can make provisions by maybe even demarcating the matrimonial home to be on whatever number of acres, and then the rest can now, if you now make a decision that you want to leave it to your children or leave it to your spouse, you can make that kind of decision while still protecting your spouse.
So then I was asking former spouses. There was something interesting. There's a High Court ruling that has recently come up. And it was actually very interesting because it has created more confusion than actually a solution. Reason being, if for example I was married, the marriage has ended, and we have property together. So I actually go to court and say, I want these assets divided. We have already divorced, or maybe we're even in the process of the separation, and we go for division of matrimonial property and say that with these assets we acquired during the pendency of the marriage, and I actually want to be given what is rightfully mine. And during the entire process, something unfortunate happens, and my spouse dies. And now
your former spouse now.
Yes, now my former spouse. Sorry. My former spouse dies. I'm still stuck up. It's moving on.
Yes.
So my former spouse dies. And now the court is telling me that we have to stop these proceedings here and actually go for succession. Because remember, the other party is no longer a party. They are now deceased. And now they're taking me to succession. Now what happens around that?
So you've opened a Pandora's box, number one. But to first take ourselves back to the law. What does the law say? So number one, previously former wives were dependents. So the law was amended, the Law of Succession Act was amended, and former wives were removed from the list of dependents, number one. And then the law also changed. Previously, the law made reference to a wife. I think there was an assumption that the person with property is the husband.
Yes.
But now I think there's an understanding that both parties may have property, and in which case they removed the term wife and replaced it with the word spouse. So meaning whether it's a husband or wife who passes on, their spouse is the one that now is being referred to in the law. Then, of course, this made it more inclusive, but it also, by removal of the word former wives from the list of dependents, it opened circumstances similar to what you're telling me, because then what happens to a divorced spouse whose former spouse passes on while either they have already filed their application for division of matrimonial property, or they have not filed, but the person has passed on, but they do have an interest in that matrimonial property. So maybe even before now we say what happens, maybe we even need to know what is matrimonial property, because we will be talking about matrimonial property, and maybe our members do not know what the law says is matrimonial property. So maybe, Njeri, you can just highlight what are the tenets of matrimonial property, and what creates matrimonial property?
Okay, when you're talking about the tenets of marriage, the Constitution is very clear that first of all, a marriage is between a man and a woman. Now, as much as we are in a evolving society, this is where we are at, because Kenya is an African country, and unfortunately, we are also bound by the practices of Africanism. So we are recognizing that there are other forms of westernized marriages that are coming up, which by the Constitution does not discriminate on, but for purposes of defining what can fall in the ambit of a marriage can only consist of a man and a woman. And for purposes of matrimony, property that is acquired from the day the marriage started to the day the marriage ended, that is part of matrimonial property. So when it comes to the issue of interpretation, the court will interpret and will adjudge on things relating to this property that was acquired when this marriage started and when the marriage ended. Now, the Matrimonial Property Act of 2013 defines also what can qualify as a marriage. And the court is saying that you actually have to register your marriage and get a certificate. And actually, even the traditional marriages, the Rorashios, you can actually apply and get a certificate and get it registered. Otherwise, it does not fall into the category of a marriage that can be recognized. So if you want to be adjudged a spouse for purposes of interpretation of the Law of Succession Act, for you to benefit to become a legal wife recognized under the Law of Succession Act, you need to have your marriage registered so that now all these assets can be adjudged within the legal ambit, and you can actually benefit as a defendant of what we call a category A defendant, who is now a spouse. So now, Bilha, I was particularly interested in what the court says in the court said in the case of FEO, which was actually very interesting when it comes to the interpretation of matrimonial property rights.
Okay. Yeah. So in terms of what, just a brief summary of the case. So a first wife lodged a division of matrimonial property suit after the death of her husband. The second wife, of course, argued that the issues of contribution towards the acquisition of the property of her deceased husband could not be determined under that application. It should be determined in a succession court. So here, Justice Musyoka took the view that death terminates a marriage. And I think that is where we are told as lawyers we like technicalities, because the word he's used was terminate a marriage. However, he's in his judgment, he highlighted that the wording in the Matrimonial Properties Act was that you can only make an application under that act where there's a dissolution of a marriage, and dissolution of a marriage here refers to divorce, annulment, or separation. So death does not create a dissolution. So, and by making that determination, he said that the suit for division of matrimonial property, he lacked jurisdiction to hear it, especially since the former spouse now had passed on. Of course, this is now a very big challenge to a former spouse. As we had given an example, if this former spouse had not applied in the lifetime of her former spouse's life, it means that she cannot be protected by the division of matrimonial property. She has to rely on the issue of succession. And
so,
of course,
so what you're telling me is that because now I went to court and my former spouse has died and I've come to claim under the Law of Succession Act. Now the Law of Succession Act is actually telling me that I am not recognized.
No, actually the law of there are other courts that have taken a different view. You see, in this instance, the former spouse, the first wife as they are calling her, went and made an application under the Matrimonial Properties Act, a division of matrimonial property. But now the judge was that this is a wrong court, you're in the wrong court. And in other decided cases, courts have taken the view to provide some form of relief because they know, yes, this former spouse needs to be heard. So this former spouse would have to now object to the issuance of letters of administration, go and say that I contributed, this property that you're distributing here is not free property. Remember, the property that can be distributed must be free property. So the view is that you now make an application there and say that this is not free property. You have to prove your contribution. So of course the stakes are much higher. Then also you'll be seeking that the court declares that property and rights that property should be excluded from the distribution until you are heard and it's determined what your contribution to that property was. So again, this still takes us back to if, for instance, a marriage has ended and one party has gone and married again, we also assuming that there's always a fight. Sometimes there's no fight. So perhaps there's a view that one spouse wants to make provisions, say for his children and former wife, without causing a fight. So perhaps the best thing would be actually to write that will, because if you do put it in your will, then there will be no reason for people to go to court and start proving contribution, among other things. And then, of course, this now brings the issue of contribution. Jerry, what is contribution? Because that's the magic word that seems to be flying around.
Yeah. So now contribution can either be monetary, non-monetary, or through physical labor. Basically, what we are saying is that it's either, if for example, I have a property and my spouse has decided to buy a piece of land, but I, the wife, there are two scenarios. It's either I'm a working wife or maybe I'm not a working wife, I'm a stay-at-home mom. So contribution can be either monetary, in that maybe he contributed the money for the land and I decided to pitch in for the building of the matrimonial home. And in another scenario, I'm a stay-at-home mom. It cannot be said because I stay at home and actually bring up the children. I'm the one who is the primary caregiver for these children. I take them to school. I take them to hospital because I have a busy spouse who is actually going out there to look for money for also our well-being. Then how does the court actually quantify this kind of contribution? It should be counted as contribution as well, because even as he was going out there working, I was at home raising our children, taking care of the home, making sure that things run properly, and making sure just basically all the welfare of the family unit is attended to. So this is now what we call non-monetary contribution. And the court is actually looking at it so intricately in that when you're told to prove contribution, how then do you prove contribution of I took the kids to school? You understand? Because they said that it is no longer 50-50 just because you're a spouse. Then I'm saying at the dissolution of the marriage, I'm coming to say that I want 50% of your assets. It's no longer the case. It was there before, but now the amendment in law has been made. But then how does the court actually take into account my contribution, and do they actually quantify? Is it a value that is given? And they say your contribution to raising kids can be quantified to 300,000. Take 300,000 and leave the marriage.
So of course these are challenges, and maybe I can highlight the case of Resma Commercial Agencies. So in this case, the facts were that the husband sold property where the family had resided for 17 years without informing his wife. Of course, the wife was raised a protest and said that this was matrimonial property, and her input was that she had created an environment that allowed this gentleman to go and purchase this property, and she did this through selling another property and giving, I think, a cash contribution, and then of course also taking care of livestock and also covering household expenses. So meaning she had contributed in one way or the other. Here, the Court of Appeal actually took a different view. The view they took was that there was no proof she contributed in any way to the acquisition of this property, as she did not submit any evidence. It was interesting in that case that her brother-in-law actually gave testimony in her support, but the court took a view that there needed to be evidence. So as you're saying, especially for, you see, the non-monetary contribution, the silent contribution or the silent labor that you're talking about, which may actually be provided by either spouse. So in most instances, yes, it's the wife,
usually the wife,
but there are also other instances where it's the husband. Maybe, as you're saying, the wife may have had a little shop, but the husband maybe was the one tilling the land. So there were things that were being done, but because these things are not receiptable, there is no receipt, it becomes very hard for the spouse to prove their contribution. So it's an evolving area of the law. Of course, the challenges are obvious in that the need for proof is, the threshold is becoming higher and higher because, as you said, initially people took a 50-50 view. That percentage issue has become a contentious issue too. Now we are down to what's the proof of what it is that you actually contributed towards the growth of these assets. So that is where we are currently.
Now does it mean that once you're in a marriage, uanze kuweka risiti? Now nikienda supermarket ninunue mkate ya 20 bob, ninaeka risiti yangu ya 20 bob. If I'm asked to prove my contribution, ninasema nililipia mkate ya 20 bob.
Yeah, of course. I mean, it's difficult because also marriage is not transactional in that manner. So I think maybe as the law develops, I think case law keeps developing. We'll keep seeing interpretations. But it's interesting that there was a dissenting view by Justice Ngugi because he took the view that the silent labor, the person who provides, whether it's male or female, the person who provides the silent labor, I mean, things have changed. Sometimes the person who is a, say, primary caregiver may end up being the male spouse or the female spouse. So his view was that silent labor that's impossible to the child care, the taking to hospital, the creating a good environment at home, those cannot be quantified. So the party that provides that kind of support to the family will forever be in trouble because you're being told to produce some form of proof
that is not there, that you cannot produce.
Yeah, exactly. That may not even be possible to produce even if you wanted to. Yeah. So now that we have laid the base, the next question would be, so now how do you hold your property? What do you do? What I mean, we have understood the things that may happen, but where does that leave us? Yeah.
So now when it comes to the different forms of land ownership, they are in two segments. There is joint property and tenancies in common. Now, I'm sure you've heard about this terminology, those of you who are owning properties, either as spouses, if you have properties, or if you have a property owned between you and your dad, between you and your brother, between you and your sister, what does this ownership means? And even in terms of how it's interpreted, and even in terms of your estate, what does that mean? Now, in the ambit of joint property, and now this is now property between spouses. Joint property basically means that you own all the land together as one unit wholly. It cannot be said that this one owns this and this one owns that. And it's only provided for where it is where it's in a family unit between a husband and a wife. Why that is so is because when spouses own property together and they actually categorically state in the title document that this property is owned jointly, then if one of the spouses dies, then this property automatically goes to the surviving spouse without the need for this property having to go through succession or even through probate. Now, the case is different when you're dealing with tenancies in common. Now, in a tenancy in common, it is one land, yes, but the land is usually owned in either a percentage or share. It is a distinct but an undivided share. So I can say that me and Bilha own property together. Me and Bilha are not related. We would only be able to own property through a tenancy in common as opposed to when I own property with my husband. And if it is a title with my husband, I say we own this property jointly, then unfortunately in the event that he dies, the property comes to me automatically without having to go through the process of succession. But the case is in the reverse when I own the property with Bilha. That is a tenancy in common, and that means that but there's a distinct share of what Bilha owns, and there's a distinct share of what I own, such that in the event, in the unfortunate event of my passing, then my own share will devolve to my estate. And that means Bilha cannot come and claim my share just because we're in the title jointly. It would mean that my beneficiaries will be entitled to my share, and they can actually, the estate can claim that share and actually benefit from the use of that property. So that's basically what the forms of ownership are. Again, you would need a lawyer to actually, when you're acquiring property, especially between spouses, it is not an automatic assumption. Just because that I am married, that we have acquired property together, it does not mean that it is an automatic assumption that once we're in the title, both of us, and I have a marriage certificate, that property is joint property. The law actually places an obligation for a spouse to actually expressly state in the transfer document that was used to create that title that the property is owned jointly. Failure to which the property will be deemed to be a joint tenancy, and that basically means property between A and V, who are spouses, will actually open up to succession. And once my spouse has unfortunately died, it devolves to the estate. And now, once it devolves to the estate, then actually it means all the other dependents and interested parties have a claim to that property. So it is important that actually spouses define these legal documents well, and you actually name what you actually write what you want written on the title. Now, you cannot also write, when it is me and Bilha, we can't say we own the title jointly. Yeah. Even if we say jointly, because me and her do not fall under that category of the rights and obligations that are actually created by the principle of joint tenancy, it will be considered a tenancy in common.
Okay. So I think maybe to add something little on your on what you've said. So we've understood what tenancies in common are and joint tenancies.
Yes.
And since we are talking about property and acquisition of property, so for instance, in the marriage scenario, so if someone acquires property before marriage or gets an inheritance or a gift, if they put property in a trust, or if after separation there is a property that has been defined to be yours, and also any property that you've excluded by agreement. So this would mean that there's an agreement that you've entered into before marriage and say this property is mine, that property is yours. So those would exclusively be this person's property. Then of course is a joint property that is owned jointly, whether as tenants in common or as joint proprietors. However, even as you say that there's this property you acquired before marriage, there would be a view that if one spouse contributed, say you acquired land, then the other spouse goes and brings in the capital to build on this land. So there's actually a contribution. So that contribution will be viewed as creating an interest or a beneficial interest for this person. So just because it was acquired before marriage doesn't mean that it's not open to discussion if there's a contribution from your spouse, the same as land that is inherited. And maybe as we get here, perhaps we can take a break. I'm hoping that we've been receiving questions in the chat box. We're going to take a brief break so that we can look at those questions and answer them. And also when we return, we will be talking about family trusts as an instrument of estate planning.
So, ladies and gentlemen, as we go for the break, please remember to channel your questions in the chat. We'll be taking those questions, and after we have discussed the other estate planning tool that is Now Trust, we are going to be taking a Q&A session, and we are going to be answering your questions and as we go.
Welcome, MAC members. Before we move on to dealing with trusts, we would like to respond to several questions that have come through, and I'll invite Njeri to start us off.
Okay. We've received the first question we've received is about the procedure, basically about what happens when you want to file for probate, or in this case, when you have died without a will, also intestacy. So the first thing that you do, we said, just to recap the conversation before, is that the first thing you do is to file a petition. So once you have filed a petition, the next process is gazettement. Now, this succession course has to be gazetted and say that the confirmation of a grant of the estate of so-and-so is coming up in this court on a certain and certain date. Now, the gazettement has to be in the Kenya Gazette, and it has to be for a period of 30 days. Once the 30 days lapse, and why the 30 days are usually given is to notify any other interested person who might have a claim in the estate of a deceased person to come either and say that I have been left out, I am a dependent, and the court will actually hear and adjudge on this issue. So basically, if you have any objection, if you have any matter to bring up to court, this is your time before a confirmation of grant has been given. So the gazettement will normally last for a period of 30 days. And then afterward, what you're given is what we call a simple grant. Now, the simple grant is just a preliminary document, basically saying that there is a process that is going on. It's a way of the court communicating that indeed we have had, we have looked at and reviewed your petition, and we are giving you this subject to a 6 months timeline for us to give you what we call a confirmation of grant. So when you have a simple grant, what you can do is that you cannot distribute the property when you have a simple grant. You have to wait for another period of 6 months for the court to give you what is called a confirmation of grant. Once you get that confirmation of grant, you can proceed and now distribute the property. Remember, all these papers will be needed at the various land registries and other places where the production of these documents are required, for as long as the properties remain in the estate of a deceased person. So all this process incurs, it can be a lengthy period or it can be a short period, depending on the number of objections or other parties that come into it and file other applications. If, for example, factors remaining constant, if there is no objection to the process of confirmation of grant, you can say maybe basically a period between an year and a half, you should have the confirmation of grant. If, however, there are other applications that have been put in by other people who are claiming from the estate of a deceased person, then the court will actually have to hear out all these applications and actually review all these objections one by one and hear them and adjudge them before they can give you what is called the confirmation of grant. Because remember, once the estate of a deceased person has been distributed, there is no way the court can come and say, now bring back all those properties. There is one child who has been left out. So all these matters have to be adjudicated upon. All the family members have to be lined up so that now when the confirmation of grant has been given, the court will now proceed and give you the permission to distribute the properties. Bilha, you can give us, what was the second question?
Okay, maybe I can cover actually there are 3 questions relating to matrimonial property. I think this is an area of interest for many. Mm-hmm. So I'll read out the questions so that then we know what it is that is being queried, and then I'll give an answer collectively. So the first one was, what happens when I purchase property, develop the property without the input of my spouse? Yeah. That's the first question. Then another question is, specify with examples of how one can prove non-monetary contribution in marriage. And then the next question was, can a property that our spouse acquires alone through a facility be considered joint property? And that question has a further question. And if property is acquired through, say, an investment company or a chama, is that also joint property? So first, I'll give an overview because it's all about matrimonial property. So matrimonial property can take the form of different forms of assets. It's not only land. So maybe there's an assumption that it's only land that qualifies as matrimonial property. So perhaps you may have obtained, say, shares in a company, in an investment company. You may have bought shares in the stock exchange. You may have, again, purchased land or any other form of assets, motor vehicles, any form of assets really can qualify. And what makes a property qualify as matrimonial property? So I think based on the questions that have been asked, one, there's a query in the direction of, do you have to have contributed directly to that one property? And the answer here is no, because you have to look at the property owned by the couple collectively, not just as pick this one and say, I contributed to this one, you didn't. Then pick this other one and say, he contributed to this one, I didn't. So the way that it's looked at is, for instance, there is this question for, say, a chama. So there's a contribution to a chama. So what if this couple, maybe the gentleman or the lady is the one who is a member of the chama, but on a monthly basis, maybe there's a contribution of 20,000 shillings. So each party contributes. Maybe you give 10,000, the other one 10,000. But the share, remember, is in the name of only one party who is a member of the chama. Then what happens? Because if this chama goes ahead and say purchases property, chamas buy land all the time, then subdivide, then give it to its members. So if you collect now that title as a party that is a member of the chama, remember that the monthly contributions your spouse was sending you via M-Pesa. So that the question now will arise. Does this spouse have an interest? And of course, the answer there would be yes. And that one would be easy to prove because of the monetary contribution. I'll also give a different example. You may have purchased shares, for instance, or in the example that one of the members has asked, purchased land and developed on that land. And yet, perhaps you even took a facility to purchase and develop the land. The question will be, your spouse may have been contributing to the household in other means. Perhaps they were paying all the school fees. Perhaps they are the ones who are paying all the monthly bills in the house. While they were doing that, it can be said that this gave this other spouse the ability to be able to go and invest. So meaning when the decision is being made, you cannot look at it simply by saying you did not participate at all. The question will be, can you prove other ways you participated into the collective basket? Then now, of course, now it will be a matter of fact, and it's hard to assume. So a lot of the questions here are based on maybe an extract of a scenario. I don't have the full scenario, but I hope I've given a guide that can explain that it's not just contribution to an asset, it's the whole overview of who was contributing and how much. And then now, of course, the court will use the facts to make a determination when we are now splitting this, let's call it estate for lack of a better word, between these two spouses, who takes what percentage. And you'll find sometimes court actually give percentages. Then maybe between yourselves you decide, as opposed to cutting this in half, you take this, it's of equal value or something like that. Then I think I have answered that. The non-monetary contribution question is going to be a challenge for a long time, because we do not have, I mean, of course the courts have pronounced themselves, and as I said earlier, we are hoping that with time, through case law or any other maybe law amendment, we will be able to have a clearer view. And
but
then I think,
but essentially what we are saying is that the issue of the non-monetary contribution, there is no laid down a set out criteria that you can say this is how the court views this matter, this is what they use to quantify non-monetary contribution. So these cases are coming up in court for interpretation. And now over time, what we're going to have is that the courts are going to be creating jurisprudence around it, and we are going to get further clarification on how exactly they are quantifying the non-monetary contribution and what actually it can considered to have met the threshold of having contributed, or rather does not meet the threshold. Because now the issue when it comes to non-monetary contribution is that it can either be in form of nurturing the family, and you see nurturing cannot be quantified monetary wise, and so that is a novel question before the court for the court to decide, did you nurture enough for you to be considered to have met the threshold of contribution or not? So I think that one we will advise as we go, as the court continues to engage and create jurisprudence around it.
okay, then maybe you can cover the next few questions. I have one more.
Yes, so I have 3 questions, and the question is, what does the law of succession say when the husband has a second family despite his first marriage being monogamous? Now, interesting enough is where the law of succession and the Marriage Act collided somewhere, because under the law of succession act, there is a section 3.5 that basically recognizes if you have a monogamous marriage. I'll put it in a hypothetical situation for purposes of understanding. If there is a man and a woman who have gotten into a marriage, and they have actually gone forward and registered the marriage, and they've either gotten married in church, or a civil marriage, which actually makes the marriage monogamous. Then somewhere down the line, the man actually goes on and procure another second marriage that is actually maybe a traditional marriage. Now, for purposes of the law of succession, is the second woman a wife? Then we have the other scenario that this man was already polygamous. He had 2 wives. Now he goes on and marries a third wife, but this
third wife is married in church, making now the marriage completely monogamous. Now, as per the interpretation of the Marriage Act and the Law of Succession Act, these two scenarios of women are actually considered wives. But however, there is a strict interpretation in the Marriage Act that actually says that for this first scenario, where the man had procured a monogamous marriage and subsequently went and contracted another marriage, once you procure a monogamous marriage, it has already closed down the capacity of a person to procure a second marriage. Now you already have a marriage certificate and you got married in church. When this man procured the second marriage, that second marriage, for purposes of the interpretation of the Marriage Act, is not recognized under law because the man did not have capacity to procure the second marriage. However, under the Law of Succession Act, there seems to be an interpretation around it that actually recognizes the second marriage as a legal marriage. So again, this is a matter that is coming up for interpretation before the courts of law. They are going to determine whether or not this person is a wife. But for the purposes of the second scenario, where the man had already procured two marriages and then the third one became monogamous, all these, the wife number 1, number 2, and number 3 are wives for purposes of interpretation. So now, for when the court is interpreting whether this person is a wife or not, they are going to go under the strict determination of Section 29 and determine whether this person is actually a dependent. That is where they are judged whether are you a legal wife or are you not a legal wife. So again, it's on a case-to-case basis. It will be brought before a court of law. They will assess the circumstances and the situation and see whether these marriages were legal and whether this woman can actually claim as a dependent. Interestingly enough, because this question has been raised, when we were dealing with the issue of dependence, Section 29 was amended and they put a subsection C in the amendment clause, which actually makes this conversation very interesting. And I'm glad the member who has actually brought up the question has actually brought it up, because the Amendment Act actually put that subclause and inserted a new clause that says, if the person can prove, if a person who comes before court and proves that 2 years prior to the deceased death, they were actually being maintained by the deceased person, they can actually come to court under that Section 29 and claim dependency, and they actually will be provided under the estate. So now, for purposes of the inheritance, for purposes of these dynamics of these marriages, if this second wife, who was after the monogamous marriage, can actually come to court and say, the deceased person was maintaining me, he used to pay my rent, he used to pay my children's school fees, he used to do this and that, they can actually come and claim under Section 29. So again, the dynamic around it is whether or not you are a spouse, so that you inherit under Category A, or whether or not you are a dependent, and you actually come to court for reasonable provision. So that is the whole dynamic around it. Okay. So, Bila, you have another one?
I think you still had some there, but I have one here. I think one of the questions here was, what happens if some beneficiaries intermeddle in the estate, and does the law take that into consideration during perhaps the probate process? And here, maybe for clarity, intermeddling just means interfering with the assets of the estate. Perhaps you start collecting rent when you know it should not be collected and pocketed. So I think, again, here, this is one of those scenarios that's a matter of fact. So perhaps when the probate process is ongoing, if this person had, say, collected 500,000 shillings as rent, through intermeddling, knowing that this should have been money that's going to the estate, I think if these facts are brought before the court will definitely take cognition of this fact, and maybe, I don't know, this would be now at the discretion of the judge, but I believe they would make sure that if there were any distributions to be done, this money that you took probably is accounted for, because actually it's an offense, it's a criminal offense to intermeddle. So maybe that's even the key highlight, that once a person passes on, unless you have authority, and authority means you have been given letters of administration, or if you're the executor, you've also gotten a grant, then you have no right to mishandle the assets of a deceased person, because that's actually a criminal offense.
So, Bilha, maybe to add on that, when we are talking about the developments that the court has made over the years, we are saying that intermeddling is actually a criminal offense, and take it so seriously that the court actually does not bow to these kinds of things. The idea is when a person is deceased, everything of theirs comes to a standstill until the death is reported, the proper process has gone through court, and actually the legal papers has been handed off to the executors or the administrators, who are actually the court appointed agents in case of administrators, or an executor and a will, who actually who have the mandate to distribute the estate of a deceased person.
Yeah.
And when it comes to development of the law, the court took cognizant of the fact, being in an African societies where we have extended families who are actually interfering with the process before the distribution of the estate of a deceased person, have actually been doing it over time. I'm sure you have seen scenarios even in the television whereby once a person is deceased, you find that the brothers and sisters of a deceased person, they come in, take the property of a deceased person and throw out the wife and together with the children. One of the developments in law under the Law of Succession Act, and it was amended to include these clauses, and actually expanded the meaning of intermeddling. And they actually said that actually intermeddling will also fall in that category of those people who actually interfere with the spouse or the children before the confirmation of grant has been issued. So if you're a brother or a sister and you decide that once your loved one has died and you're going to go and throw out their wife and children, it will actually fall under that category of intermeddling, and will actually be subject to criminal proceedings. So it is important that once someone has died, every other thing relating to their personal assets comes to a standstill until all the legal procedures are followed and a confirmation of grant has been issued. It is only upon issuance of that confirmation of grant that actually someone has authority to proceed and distribute the property.
And maybe I can add something there, because perhaps you may find that the deceased person, say, had children in school, and you see there's the law that says you should not intermeddle. So the law also does provide for limited grants, and this allows members of the family to approach the court with a very specific ask. So as we said, since you cannot go and collect the rent and pocket it and say, I'm paying bills, you can actually go to court and actually say that for purposes of A, B, C, D, we are seeking the court's permission to do A, B, C, D with this money in relation to, say, beneficiaries that need to be catered for immediately. Maybe he has a person with special needs in the family, or is in hospital. So you need the authority of the court. So I think that clarifies, so that in the event there is an emergency, there is actually an avenue, a legal avenue to get access, and not through decisions that are made somewhere in somebody's house. Yeah.
So
Please
I think
proceed.
for my second question, the question was, what can one do to protect and secure one's properties for her children alone? So I think this is a broad question, but also for purposes of protecting your children. Again, we are saying, if you fail to plan, you plan to fail. So we are saying there are estate planning tools that are available. And just now we are going to be looking into the other form of estate planning. But essentially, we are saying one of the processes in which you can use to protect your children is through a will. Again, I'm taking note. I'm answering this question with a very high rider, because I'm saying properties for her children alone. So if the properties also fall under category whereby you are actually trying to kick out your spouse out of benefiting, and actually trying to give all the properties and will away all those properties to your children alone, then remember, the law also comes in to cure injustices and also mischief. So you should ensure, even as you're protecting your children, that all these properties, that if you have other dependents, including also spouses, you have to categorically provide for them, or if you're excluding them, explain away why is it that you're excluding your dependents from your will or from the other estate planning methods. So we are going to be looking at trusts as the other form of estate planning. Immediately we are done with the other questions. So the third question said, what does the law of succession say about the second wife who has children out of wedlock? I am not sure what was meant by this question, but I am thinking maybe I'm thinking someone is a second wife, but I don't know whether you came into the marriage with children from another marriage. That is now, by the time you're becoming a second wife, you already had children from a previous marriage, or rather you're saying you went outside the
Second marriage.
matrimony and actually got children out of out of wedlock.
Yes.
So you see now, if it's in the first instance whereby you came into the marriage with children from a previous marriage, and these children are actually being provided for by the deceased person, then automatically they are dependents of category A and they're entitled to benefit from the estate of the deceased person. However, in this second instance, now it becomes a novel issue also of about what do we call it?
I think they may still
Benefit
suffice
under the
as
estate.
dependents if this spouse, now the husband, adopts and not adopt legally, but say even with knowing this, continues to take care of these children.
Yeah.
Then they still have an interest in the estate, because remember that there is you can create dependency. So if you can prove dependency and this person continues to support these children, even if they are not biologically his children, then there may be
because I know the question is quite broad, but it may also cover a situation whereby these children were actually gotten out of wedlock, but the deceased did not know that the children were not his. So actually they were raised up by the deceased person, knowing that these children are my own children, of which he did not have a problem providing for them, but it's only the wife who knows that these
remember
children
that
are not
the
his.
act says that children, whether biological or not. I think that is
so going by that interpretation, we can actually say that these children can actually benefit under the estate of a deceased person.
Because
but whether
biology.
On the issue of morality, I'm sure that is something now the court will have to develop jurisprudence on, because on the strict interpretation of the Law of Succession Act, they actually depend
Their
on
children, yes. Their children and their dependents.